Hello, everyone. My name is Taylorann Vibert. I am a student at UConn, and I will be moderating the third and final panel. This panel, titled Critical Approaches to Pedagogy and Practice, will focus on ways to teach and practice evidence from a critical perspective. Please allow me to begin by introducing our panelists. Professor Lauryn Gouldin is a professor at Syracuse University Law, where she teaches constitutional criminal procedure, evidence, constitutional law, privacy law, and criminal justice reform. Her scholarship focuses on the Fourth Amendment, pretrial detention, and bail reform, and judicial decision-making. Professor Gouldin has a JD from NYU, and following law school, she clerked for both the Southern District of New York and the Second Circuit before spending several years as a litigation associate. Professor Nina Chernoff is a professor at SUNY School of Law, where she teaches a critical evidence course titled Evidence, Injustice, and Advocacy, as well as evidence and forensic evidence courses. Her research focuses on the right to a jury selected from a fair cross-section of the community. Before entering academia, she was a staff attorney in the Special Litigation Division of the Public Defender Services for the District of Columbia. Professor Chris Goodman is a professor at Pepperdine School of Law, teaching evidence, constitutional law, trial practice, racial justice, and comparative anti-discrimination law. Her research focuses on racial bias and anti-discrimination. She is the author of The Color of Our Character, Confronting the Racial Character of Rule 404B Evidence, as well as the California Evidence Book in the Examples and Explanation series, as well as a co-author of Mendez's Evidence, the California Code, and the Federal Rules. Prior to teaching, she was a civil litigator. Attending virtually is Professor Jasmine Harris, a professor at University of Pennsylvania School of Law. She is a law and inequality scholar with expertise in disability law, anti-discrimination law, and evidence. Harris serves as a co-editor of the evidence treatise McCormick on Evidence. Prior to academia, Professor Harris clerked for the Southern District of New York and practiced complex commercial litigation at a firm and public interest law at a nonprofit organization. Also joining us virtually is Professor Montre Carodine. She is a professor at Alabama School of Law, teaching evidence, law, and popular culture, critical race feminism, and major race trial. In addition to her scholarship, she's a graduate of Birmingham's FBI Citizens Academy, has chaired the American Association of University Women's Selected Professionals panel, and has served as a member of the Alabama Access to Justice Commission. Prior to academia, Professor Carodine clerked for the Fifth Circuit Court of Appeals and then practiced as a litigation associate. Thank you all for joining us. I'm so thrilled to be a part of this panel as both a student and future attorney. I think this is just a real treat to have you all. I'd like to begin with maybe the most obvious question, I think, is how? How do you teach evidence through a critical lens? I'd like to turn to Professor Chernoff first, if you'd like to talk about your critical evidence course.
Great. So I've taught it one time, so I'm an expert. I have this course that's built on the scholarship and innovation of some of the people that you've heard from already. So I'm completely geeking out because my whole syllabus is live and I'm meeting my heroes. I'm really excited. And in particular, my work is based on the insights from Jasmine Gonzalez-Rose's article, Toward a Critical Race Theory of Evidence. It really changed the way I teach evidence and gave me the framework for this course. So I thought I would take 5 minutes to tell you about my goals for the course, the content, and what the assignments are, the work that the students do. So my first goal was to educate myself more on critical scholarship, and those of you who teach or anyone who's had a deadline knows that if you have to talk about something at 3:30, you will do the reading that you'd been meaning to do otherwise, so it got me going on that. And my second goal was to have more time to dig into the topic, because although some of these issues I raise in my regular evidence class, it's always an inadequate amount of time for myself and for the students. So I really wanted to have that time that I was craving in my regular evidence class. And my third goal, a little more amorphous, but was to help and participate with my students in sort of a discipline of hope. Because I teach at the City University of New York, which is a public interest law school, and my students are very attuned to the injustices of the world, as I'm sure many of you are, if you're here. And it can be pretty discouraging. It's hard on the spirit. And so part of what I wanted to do was not just focus on the critique, but also think really creatively and in a kind of rigorous way about possibilities for reform. Actually, my students don't love the word reform, advocacy approaches. So space to think creatively about that. So the content. I zeroed in on 6 evidence rules, and of course there were many more that I wanted to tackle. But my structure that I was aiming for was really to have 2 classes for each rule. And the first class would focus on the critique, and the second class would focus on advocacy strategies. And over the course of the semester, we created an ongoing, ever-growing map of possible advocacy solutions to the problems that we are seeing. The 6 rules, or 6 or 7, the first set of rules was relevance and Rule 403. And we looked at that largely in the context of rap lyrics, which was built on the work of Professor Dennis. The second rule we focused on was Rule 702 and how to bring in experts. See, this is like ringing a bell, right? So everything that, all the people you heard from. So Assis Bassin came and was a guest in our class talking about the Evidence Equity Project and how to bring in people as experts to testify about the racial realities that they were familiar with. The third rule was 606B that looks at how to ferret out or how not to ferret out racial discrimination in jury deliberations. And that was based on the scholarship of Daniel Harawa. The fourth rule, 609, impeachment with a criminal conviction, and that was based on the scholarship of Montre, Carodine, and Anna Roberts. The fifth was racial character evidence under 404 and 404B, based on the scholarship of Micah Thompson and Professor Goodman. And 6 was adoptive omissions by silence, where if you're taking evidence now, you're probably not there in the semester yet, but sometimes staying silent in the face of someone else's comment gets treated as you essentially saying, yeah, I completely agree with that, which ignores all the reasons that people might stay silent. And that is based on the scholarship of Micah Thompson again, Maria Ontiveros, and an Excited Utterance podcast with David Slansky. And so the third thing I wanted to tell you about was the assignments. So the assignments are weekly written reflections on the reading in response to question prompts that I provide. Oh, I forgot. And finally, I had a class on jury selection, like who's hearing all this evidence or who could potentially be hearing it. And there we benefited from the expertise of Professor Will Snowden and the creator of the Jury Project in New Orleans. So the assignments were these weekly writing reflections. Second, they had a responsibility for leading at least half an hour of a discussion on the rule of their choice. And the third component was a final presentation where they would choose their audience, like community members, judges, defense attorneys. They would critique and explain the oppressive operation and history of a particular rule, and then propose an advocacy solution. So that's the class. I obviously got lots of ideas for the class this morning, so I'm not going to change the syllabus immediately. But I would really be eager if anyone has an idea, either you're an expert or it's like a half-baked thing that's occurred to you about what rules we could tackle or what resources I could include. I would be really grateful to hear about them.
Thank you so much. I'd like to invite Professor Harris to weigh in next.
Hi, everyone. Can you hear me okay? Mm-hmm. Great. Thank you so much, Taylorann, for moderating this panel. Thank you to the law students and organizers of this event, and to my fellow panelists. My apologies for not being able to be there with you all, but I've enjoyed, with my coffee in hand, the morning so far and the early afternoon. So the question that you raised, Taylorann, the first one is how we teach it. And I kind of want to just quickly, with the time I have, back up and say 3 points in terms of the order. The first is the what, the second is the why, and of course the third is the how, which is the question you asked. But just to preface that with the what, which is when we talk about, and some of this came up this morning as well, when we talk about a critical lens, what do we mean? And so where I see my contribution in this conversation is adding disability studies, critical disability studies, as a critical lens in this conversation and in the literature and in the pedagogy itself. And the why there is because, well, it's part of our broader conversation, the fact that there are over 61 million adults with one or more disabilities in the United States means that we're talking about individuals with intersectional identities. And then if you look in spaces like criminal justice, you have a disproportionate number of folks who are subject to criminal justice contacts being people with disabilities. And so there's this neglected piece of our work on critical evidence if we don't include disability there. And so what does it mean to take a critical disability approach? It basically, along the same lines as adopting a critical race perspective or a critical feminist perspective, you're questioning the baseline, you're questioning the set of assumptions that make up the doctrine, that make up the case. It's not just about the identity of the people in the case itself. So, for example, it's remembering that the institutions itself, the legal system, was designed by non-disabled people for non-disabled and neurotypical individuals. And so my work really focuses on how do we complicate the story when we challenge that very core assumption, as critical legal theorists do, to take the baseline and show that it's missing something. So the how could be, it's a range, it's a continuum. So the interventions I make in class, depending on what I'm teaching, like Nina said, if you have a larger survey course on evidence, your ability to ask the follow-up questions, it's more constrained. And I know we'll talk about this later in this panel. But even in that class, it's giving students a set of critical questions that centers power and centers the context as being particularly important. And so it's like adding to your critical toolbox, saying, you know, what is the identity of the litigants itself? What was the context? Let me move into the how to give you some concrete examples. Where this comes up the most and where it's easiest to do, so I'm going to start on the easy end of the continuum, is thinking about concepts such as flight and what we can understand from flight. Think about the context of people with intellectual and developmental disabilities, someone who, for example, is on the autism spectrum. The notion of flight, well, fight or flight response is exactly part of their disability. And so flight might be a manifestation of their disability as opposed to persuasive proof, probative evidence. So that's one place where it's easy to kind of push on that. But as Nina said, there are a number of interventions that you can make depending on how much time you have. And so I talk with my students, building on the work of everyone here at this conference, questions about relevance. So what's the nature of the case? If it's, for example, the work that I've done in sexual assault cases, if it's a sexual assault case and it's a question about the survivor's capacity to testify or their capacity or their credibility, how relevant is information about whether they can practice self-care, such as showering independently? How relevant is that? Yet these types of facts come into evidence regularly to undermine the credibility of individuals with disabilities who are involved in the legal system. So I'd say relevance, expertise, the whole notion of medicalized expertise, the endeavor of it is in direct conflict with some of the disability rights paradigms and trying to center expertise in people with disabilities themselves. And so our doctrine runs counter to some of these anti-discrimination efforts, as others have talked about in other contexts. So I'm going to stop there, but that's a little bit about my how, and I did want to include the why because I think it's important as well. Thank you.
Thank you so much, and let me amend my question to also include why and all the other things you touched on. Professor Carodine, would you like to take the floor next?
Can you all hear me well? Great. Thank you so much for having me. Taylorann, thank you for all of your hard work. Professor Simon Kerr, thank you for recommending me to the students, and thank you to all of the students. on the public interest journal there at Connecticut for this very important program. It's so exciting. I wish I could be there, but I've enjoyed the program. I've been logged on all morning and early afternoon, and I've just really, really enjoyed it. I've taken a lot of notes and have gotten a lot of ideas. So I'll just speak briefly about uh, what I do, how I incorporate uh, kind of a critical lens. In particular, I focus on race uh, when it comes to evidence. I really kind of flip the script. I use um, evidence kind of as the lens, right? To me, race is the focus. Race is so deeply embedded in the law. It's race in the law. And I use the evidence rules kind of as a lens in some of my seminar type classes, my smaller classes. For a number of reasons, we could talk about it later, in response to maybe some of the other questions, I don't find the kind of big bread and butter evidence class to be, at least at my institution, the best space to have a discussion about race, the type of discussion that I think needs to be had, the type of in-depth discussion that needs to be had. So several years ago at Alabama, I created a class called Major Race Trials. And what we do in that class, I haven't taught it because I've turned my focus to some other classes, and I'll talk about that in a second. But what I do in that class, hopefully I'll get to teach it again pretty soon, is to look at like really major big trials, race trials throughout American history, and really focus on the concept of race as evidence in those trials. And the first thing that I do in that class, the first part of the syllabus, starts out with critical race theory. So I introduce students to the concept of critical race theory. So we read Derek Bell. We read, I introduce the concept of whiteness as property. Some of the major kind of tenets of critical race theory we start with. I also assign my own piece about race and evidence, focusing in particular on prior conviction impeachment. But the meat of what I use that piece for is the idea of race as evidence. And then I use Jasmine Gonzalez-Rose's amazing work toward a critical race theory of evidence. And we focus on particular rules of evidence. So in particular, I look at the character rules of evidence. So that's kind of the first part of the course. And then after about 2 or 3 weeks of really immersing ourselves in that material, we start to look at the trials. And I won't go into every single one that we do, but I'll tell you some of the materials I use, and then I'll give you the examples of the trials. But for the materials, I use Professor Annette Gordon-Reed's Race on Trial compilation. I also make use of Professor Douglas Linder's Famous Trials website, which is an amazing source. It has all of these original documents. The students can actually see trial records and news articles and that type of thing, from back then when the trials were unfolding, and it's really impactful for them. And I use law review articles as well, a variety of them, and I make use of film. That's very important for me. I think film is hugely impactful with the students. And in fact, I use film in every class that I teach. I actually teach a law and popular culture class where we focus largely on film. And so that's a really big part of what I do. So we study cases like the Amistad case, we study Celia a slave, we study Korematsu, O.J. Simpson, the Zimmerman case, among others. And when it comes to film in particular, we look at documentaries on the O.J. Simpson case. We look at the case involving Jack Johnson, which Annette Gordon-Reed has an essay in her Race on Trial book about. And there's a wonderful documentary called Unforgivable Blackness, that deals with that case and all of this amazing history surrounding the trailblazing Black heavyweight champion Jack Johnson. It's so amazing to watch the students' journey through all these cases and realize how much they didn't know. I mean, I learned a lot myself when I started teaching this class, and they learned so much. And that's powerful in and of itself, especially when you think about, for example, the rules of evidence or the rules of procedure. They're like, why didn't I see this? Why didn't I hear about this in my larger evidence class? There's power in that. There's power in sitting back for a minute, I found. Let them go through the traditional way of teaching evidence. And I'm there waiting for you to show you this side. And I found that to be very, very powerful in sparking curiosity with students who want to know more. And so I could go on and on, but I do want to mention one other case in addition to the Jack Johnson case. The cases that I find the most impactful, the Jack Johnson case, those are kind of that's where you have a turning point in the class. So I highly recommend that and the Unforgivable Blackness documentary to go along with that. And then another powerful turning point is a documentary, a PBS documentary from their First People series. We focus on a case involving the so-called Kennewick Man. It gives this historical background and context for a nearly decade-long battle legal battle of a Native American tribe to secure the returns of the ancient remains of one of their ancestors, who they call the Ancient One. Scientists were calling him Kennewick Man. And so we go through it. It teaches a lot about scientific evidence, which is one of the reasons that I assign it, but it's hugely powerful for the students. And the film that goes along with it is just absolutely breathtaking and amazing. And I find that to be a turning point in the course too, that along with the Jack Johnson case. But that's just some of the examples in their documentaries with the O.J. Simpson case too. There's a lot of powerful stuff out there too. I find the ESPN documentary to be really powerful there. That's just a taste of what I do in major race trials. I also teach critical race feminism. I make use of film there. And we focus some in some of that class on trials. There's one in particular, the Madrigal case involving the forced clandestine sterilization of Latina women. We look at a documentary on that. That's hugely powerful. And we do a number of other things in that course as well. And then I have law and popular culture that I teach, and we focus on film, a lot of film about trials, documentaries as well. All of these opportunities I have to bring in evidence, to talk about evidence and to show race and racism through the lens of evidence. So I'm able to do that in those courses. I find that the way that I approach race and evidence in that way to be the most impactful, again, much more so than I could do in the big evidence space. But I'm happy to talk more about other issues and why I chose this route, but I want to give the other panelists an opportunity as well to talk. I don't want to take all the time up. But thank you. Thank you again for having me.
Thank you so much. Professor Goodman, would you like to?
All right. Well, again, it's so great to be here, and I'm geeking out. Thank you for having me. I try to look at things from a perspective that I gained from my evidence professor. So all of you look towards your evidence professors and recognize that some of this stuff carries on. The late Professor Mendez was my professor, and he had grown up in Texas, and I was in school in California, and he was teaching us the California rules of evidence, but he would always say, well, in Texas, and then he'd tell us how things were different in Texas. And that started my mind thinking about, well, if the rules are neutral, if the rules are, they're objective, why are they different in Texas? And I didn't know a lot about Texas. I didn't spend much time there, but that just kind of percolated in my mind. Then when I became a litigator, I didn't have time to delve deeply into why are the rules this way. I just had to get up and object and, write my motions, do my arguments. But then when I started teaching evidence and I got to do the really deep dive, I really realized they're different in Texas, they're different in California. New York has no evidence code. There's all these things. So again, how are these a priori justified? All right, and so then I started thinking about justice and fairness, right? And for me, I look at it from the perspective of John Rawls's theory of justice. If we were all behind this veil of ignorance, we did not know what we were going to look like, where our position in society was going to be when we came out, what rules would we create then, not knowing where we're going to be? And I look at the evidence rules in that way, and they are not created behind that veil of ignorance. They are created, as other panelists have said, based on who was doing the drafting. And none of them look like me, and none of them look like many of us in this room. And so I try to incorporate that even into my large evidence class, because these are the people who are going to be part of law reform. They're going to be making the arguments in front of judges. Some of them are going to be judges or clerking for judges, so they can have just little inputs into this idea of, wait a minute, is this really how it has to be? And so I started focusing on going back to another one of my law professors, Chuck Lawrence, The Id, the Ego, and Unconscious Racism, one of those seminal articles that helped to start this movement, and looking at the cultural meaning of evidence, the cultural meaning of things people say, of, as we were talking on the earlier panel, hand signs or gang signs, right? Hair coverings or do-rags, all those types of things. So when we're reading cases in my class, when we're going through hypos, I really focus in on how would things be different if the description of the defendant were different. I asked my students to put themselves in the shoes of the defendant, and how would things come out differently for them, with their background, with their looks, with how they are usually treated. So that's part of what I do. And then the other thing, can I say one more thing? Okay, so the other thing that I really focus in on, and again, that's why I'm so excited to be part of this symposium, is the idea of character evidence, right? That's where I first started looking at it. But what I remind my students is the character evidence rules basically say none of it can come in unless the criminal defendant opens the door, right? But we know the back door is 404B, and all of this evidence is coming in anyways, that they can't explicitly use it for a character purpose. But then I also remind my students that the doctrines of primacy and recency are in favor of the prosecution as well. Who gets to go first? The prosecution. Who gets to go last? The prosecution in their rebuttal case. The same with if the defendant decides to bring up good character and open that door, well, guess what? The prosecution's going to walk through that door with the bad character. What does the jury hear last? The bad character evidence. What are jurors more likely to remember? Everything else being equal? Bad character evidence about a defendant, not good. And so it's not even always racially charged. It is, though, always charged against the defendant. So that's some of the things I try to just imbue in my students. So along the way, they are always questioning the rules. They know how to apply them, but they're questioning them.
Thank you. Professor Gouldin?
Yeah, I think I'll echo, first I'll echo the thanks of everybody else. This has been really terrific, and I'm excited to be here with so many friends and colleagues and people whose work I cite and am inspired by. But I shared the same perspective about trying to teach the big classic evidence class and trying to find as many opportunities as possible to, I think Professor Simon Kerr said this morning, debunk the myth that these are sort of fixed, neutral rules, and really push students to try to interrogate why the rules are crafted the way they are, how they play out in practice, and who gets disadvantaged by that. For me, a lot of what interests me in the evidence classroom ties in with some of my scholarship, which is not evidence scholarship, but feels sort of evidence adjacent. I'm fascinated by the problems with the way that we make decisions, and I'm another one of the panelists today who's a little more focused on the criminal law classroom, criminal law system than our civil cases. But I'm really fascinated in my scholarship on the problems with the way we make decisions at two different points in the criminal system. So more recently, I've been writing about the ways that police officers judge suspicion, the way they put together evidence about what qualifies as suspicious behavior by people that they're watching, and how they use those suspicions to then conduct searches or stops or make arrests. And then I'm also really interested in the pretrial context, in the ways that judges make decisions about things that we label as risks. And I think one of the things that I continue to try to bring into my evidence classroom that really feels like we don't do a good enough job with this across the board in legal education, in my opinion, is the evidence from psychology that all our assumptions about the ways that people make decisions don't actually match with the data that's available. Professor Simon Kerr's work here is so terrific, as Professor Roberts was saying earlier. But we really need to do a lot more to sort of revisit the assumptions that underlie all our evidentiary rules that are now getting debunked by work that's being done by scholars in other fields about problems with decision making. So I'll wait and talk about some other specifics as we move on, but thanks. I'm really happy to be here.
Thank you. Oh, go ahead.
I know I already talked, but I spoke before about my advanced evidence class, but I did just want to share some of the things I do in my regular evidence class, which is the big doctrinal class, to try and incorporate some of this. So I start out by saying it's like inherently unsatisfying amount of time, but still some of the things that I try to do is first require critical reading for some of the rules where it's the most salient. We have 609, character evidence, things like that. And then I have optional critical reading for lots of the other rules. So if a student's interested or they're feeling that something's wrong with a rule, it's a way of saying you're right. I also have an assignment at the end of the semester. Students have to draft for the Evidence Rules Committee a proposal for changing, eliminating, or adding a rule. And so it helps activate the idea that these are creations by people and we could create new ones. It also familiarizes them with the Evidence Rules Committee process, which I was practicing for many years, had never heard of, so it was something I wished I'd known. And also it means that whenever we're talking about a rule, we talk about it, when students have critiques of it, we can say, okay, that would be great for your rule proposal. Like, it keeps us in discussion about how the rules should be changed. I also have homework questions that are built a lot on Professor Gonzalez-Rose's questions. So questions like, how does this rule support existing power structures? Or how does this rule silence the voices of marginalized people? And I'll often ask questions like, because of a very diverse law school student body, how do your own life experiences give you insights on this rule that you didn't see reflected in the reading? And so I'm continually learning from my students when I read their answers. And then finally, I start the class with an intro video that looks at the timeline of the development of evidence case law, then the rules codifying the existing case law in 75, and then the case law that interprets it, and just overlaying that with the timeline of slavery and legalized segregation, and looking at the pretty profound lack of diversity on the bench and the very profound lack of diversity on the Evidence Rules Committee, just so that we can concretize and recognize the fact that evidence rules are based on common sense, but it's a very impoverished common sense. It's missing a lot of common sense. And for that, I really also start with Professor Caper's article and insight about evidence without rules, and trying to make it part of the class to name the evidence that jurors and fact finders are using that's not officially part of the evidence and rules analysis, but is definitely officially part of how people decide cases, and keeping that in the front of our minds as we discuss the rules.
Thank you. I am also curious, over both the course of your own teaching experience, or since you were in law school as well, how the receptivity towards critical theory in law school curriculum has changed. And I think we can maybe start with our virtual panelists. Professor Carodine, if you wouldn't mind.
Oh yes, thank you. Thank you for that question. Oh wow, it's changed a lot since I was in law school over like 23 years ago. I mean, it just didn't exist. You didn't, at least at my law school, which was a diverse law school, um, and fairly progressive. Those types of discussions that just didn't happen in a class like evidence. We did have critical race theory, but even then, there really wasn't an incorporation, as I recall, in my critical race theory class, um, of areas like evidence where there's a specific discussion of certain rules and how they operate. It was more of the literature, like similar to what I was saying I exposed my students to at the beginning of major race trials. So, there's Cheryl Harris's whiteness as property, there's that type of thing, but there's not a focus like what you might see now, what we're hearing about now. And part of that may be just because of the scholarship has changed too. Like we've changed what we're looking at. I remember when I first started writing about race and evidence, there was very little out there, and it's just so amazing now. I'm so excited to see everything that's out here now. So I think in some ways we've led a change with our focus on our scholarship and introducing these new classes. Also, the students have changed. Just over my time teaching at Alabama, I've noticed even the makeup of my classes. So a class like law and popular culture or critical race feminism, those usually fill up pretty quick, and there are times where I have waiting lists for those classes. It used to be when I got here, they would be full, but it would be almost all Black students in those classes, which is perfectly fine with me. Whoever wants to take the class, I love it. It's changed now. It's almost the opposite. That I have less students of color in the classes, and I have more white students who are clamoring for to get the class, getting up early and getting on, logging on to register. Is really an interesting dynamic. I think my next move is to try to open it up so that anyone who wants to take the class can take it. I want it to be as open as possible, but yeah, I think it's changed. Who's interested in these classes, and just and the knowledge that students come with, like the background that they come with language already, because they're taking some of these classes, like they're taking critical race theory in undergrad. They're learning about even critical, just generally critical legal studies, feminism. They're learning these things in their undergraduate courses, and some even are learning them, in other spaces. So they come with receptive and ready, more so, at least in my, my smaller, more the advanced classes with the traditional bread and butter evidence. Like, a lot of the students are coming for, they want to take the bar, they want to litigate, they want to take evidence for that reason. But even in that class, I often don't bring up race for a number of reasons, and I actually have an essay that's about to come out in the book Integrating Diversity and Doctrine. I think it's going to be a really good compilation of scholars talking about how we incorporate these issues in our classes. But I kind of don't bring race up usually, like in the way that I would do in a major race trials class or critical race feminism, another type of class, in the way that I think it should be done. However, I have students who will bring it up. I have students who will raise issues of race, and I'm always happy, like I always entertain any student question anyway. I'm always happy to have those discussions. And so I've seen a shift in students who are not just brave enough to bring up the issue of race, but eager to talk about it, which I'm happy to oblige. Now, I do have students who are just the opposite, who are hostile toward them. And I talk about that in my in the piece that's about to come out. But I do think we're seeing a shift. It is different. It's changed over time, and it's not just the students of color who are bringing up these issues. Students from all walks of life are bringing up these issues, and they come so knowledgeable. So it's really exciting to see. I think my vision, what I hope to move toward that we move toward is that there will be more mainstreaming of classes like political issues, not, discussions and hostilities aside for a second, but there'll be more mainstreaming of classes like critical race theory, because I do think we're seeing more of a student hunger for it, which gives us also the opportunity, like I said, the way I do it, flip the script to look at race through the lens of evidence. So I'm seeing, bottom line, more receptivity. It doesn't mean that there isn't hostility, because there still is, and certainly in some parts of the country more than others, in some schools more than others. But I'm seeing a shift, and I'm very excited about it.
Thank you so much. Professor Harris?
Sure, I just want to echo that, I think when I was in law school a long time ago, the focus on anything, the evidence class that I had, quite frankly, was a comparative evidence course. It was taught by an international law scholar. It wasn't something that really focused on US-centric issues, despite being about US law. So I think I took to heart that was the model, and have worked to push against that since. So I feel like absolutely Montre's description of the tide turning, it's really, the student demand is absolutely there. And students see law school as an opportunity to also shape the type of education they want, and there's more confidence and there's more support for that. I think faculty, many of whom are here, who want to see that. I do want to put on the table, despite that I think the structure of and this continued siloing of the critical perspectives and evidence remains. And so, it's not surprising that most of us are talking about how the innovative work we're doing is in the seminars, away from the bigger, larger class. And why is that? Well, it's because there's a lack of institutional demand for that. Let's be clear, you've got the student side demand there, but the institutional structures that are there, ranging from the bar exam, but quite frankly, students are going to have to study for the bar exam anyway. We're getting to the topics. So that's not legit, right? So can we start to get to the real core of why having these classes and putting critical race on the table, or critical perspectives, is often siloed as extra, or if you want a critical lens? I think we need to change the conversation to, we must have a critical lens because it's there anyway. And we're basically practicing silence by not taking it up.
Thank you so much. I'd like to open this question to our in-person panelists as well, if any of you would like to weigh in.
I think I would just agree with what our online panelists have said. I do think that deeper dives into these questions happen in the seminars, and I agree with Professor Harris about that. Absolutely, there's just more space and time to dig in those courses, and so that is a constant struggle in the big evidence class to try to give these topics their due, and so I don't have answers for how to do that, except that I reach out pretty frequently to a lot of the other people in this room for advice about how they weave some of these things into their classes. So I think that's one of the solutions, but agree that the student appetite for this is strong, and I would say things have shifted tremendously, given shifts in perspectives in the community about drug policy reform, criminal justice reform or abolition, racial justice, sort of greater consensus and understanding about economic disparities. It feels like the starting point for a lot of these conversations is pretty different than where it was a decade ago or 2 decades ago.
Thank you.
Just a little bit. So way back when I was in law school, I learned criminal law from a critical legal studies scholar. And so everything was questioning everything. And again, that was my first year in law school, so that just was something that was always part of my mind. But I've seen the pendulum swing back and forth in terms of student receptivity to critical theories. And every time someone gets, killed at the hands of police officers and they're black, every time there's a shooting, every time there's a resurgence of students who want courses related to racial justice. But I mean, there was a time when I was teaching race in the law, and I was informed by the administration that I probably shouldn't teach that class anymore because it's kind of divisive and not a lot of people want to take the class. And so I broadened it then to anti-discrimination law, and I covered gender, sexual orientation, disability, all kinds of other categories of difference. And then a few years later, there was another beating or murder, and suddenly we need classes again to do this. But thankfully, we now have my racial justice seminar I teach every year. We also have someone else teaching race in the law and someone else teaching a DEI course. So there's it's going in the right way. But then I lament for my colleagues in states where CRT is being banned, where they are afraid to teach. And so I see that backlash as well, and particularly in light of the affirmative action cases, I'm not sure how much further back it's going to go.
Thank you. I'd also like to refer back, Professor Chernoff distinguished earlier between her doctrinal evidence course and her critical evidence seminar. I'd like to invite more discussion about teaching that doctrinal course. Evidence is an important black letter law course where a lot of students enroll for that narrower purpose of learning the rule and passing the bar. So how do you strike that balance between teaching the rule and teaching with a critical lens?
Can I jump in? Yeah. No, did you go?
You go first. I just.
Let's just alternate sentences. Go back and forth. Okay. I just think sometimes it takes so long to teach a rule where race and racism is motivating it, and you don't talk about it. It's more confusing for students. 609 outside the context of criminalizing blackness doesn't really hang together as a story, and I get stuck there at the front of the room trying to make sense of this rule or describe it, and the logic that's motivating it is racism. And so sometimes I find it's not, although to take time to read articles that highlight the theory or that make the critique adds to the time that it takes. I think in class sometimes it's faster and more efficient to really name what is the force motivating the rule, and it's easier for students to understand for that reason. So I just posit that it's not always hard to balance, it's sometimes harder to leave it out.
No, go ahead.
Yeah, so for me, it depends on what semester I'm teaching evidence. If I'm teaching it in the fall, I have those who want to be litigators, those who want to do clerkships, those who want to use it and are not just taking it to study for the bar exam usually. So then I can do a lot more. So I teach that one as 4 units. When I'm teaching it in the spring, it's the third years who put it off till the last minute because they need to take it for the bar, because it's required, that sort of thing. And I get a lot less enthusiasm. So then I only do 3 units of evidence, and I don't go into as much of this detail. But part of it is making sure that I start with the rules. I start with, let's go through the rule as it is, and let's delve into that really deeply, and then we branch off, okay? And I think part of it is I have to branch off because as a black female in front of the room where there are racial implications to the evidence that I am teaching them, if I don't say something about it, if I don't address it, it doesn't give the students who may be thinking that the permission to address it either. And it's not their place to have to raise these issues. Thankfully, many of them do and will, but I feel like I'm not doing my job if I don't bring this up because it's going to be in their minds, and I need to be an example for them.
Thank you so much. I'd also like to talk about one thing that has sort of caught the attention of law schools. In February 2022, the ABA adopted a new standard requiring law schools to provide education to law students on bias, cross-cultural competency, and racism, both at the start of their legal education and once again before graduation. Has this new requirement affected your institution or your coursework? Has it been an encouragement or something that's already happening?
Yeah, yes, so we have new requirements. I would say in some ways this maps onto some of the prior questions. So for me, I don't try to claim that my evidence class digs in deeply enough with these issues to satisfy those requirements, but I expect many of us are teaching these seminars where that's very clearly, you know, part of our motivation for teaching the seminar matches the motivation that the ABA had in adopting those rules. So I think it's definitely influencing those smaller courses. And the more I do in the smaller courses, the more that I find ways to incorporate that more seamlessly into the big classes. So I don't know if that's responsive. But.
May I jump in for a moment? There's just to add to that. I think that it's all about, again, how deep is your toolbox? How deep is your bench here? You can find ways to incorporate the critical legal perspectives pretty seamlessly on one or two questions. And I think the ABA directive is useful because you can say, this is a priority. However, I worry that the priority gets satisfied by the seminars. And so one way in other areas that I've seen this play out pretty well is, you know, folks who do critical theory will offer to colleagues in torts or, you know, in con law, where there are concepts that are clearly ones that lend themselves to critical theory. But let's say the colleagues feel uncomfortable or less sort of ready and able to lead those discussions and offer to go into those classrooms. It's a lot of extra work for us, but I think part of what that does is show that there is space for it and that it's required. And so if you can get our colleagues across institutions, you know, really on board with the importance of this, I think that's the only way we're going to move past the silo.
Thank you so much, Professor Harris. I'd also like to dedicate a good amount of time to talking about practice, particularly how critical perspectives prepare attorneys for practice. I'd love to hear also whether these critical perspectives are actually making it into arguments or briefs in court.
Well, okay, I can start. So much of it, I guess, depends on the type of practice, what your practice area is, and the makeup of the attorney's clientele. But I think the critical theories still make us all, like, that approach still makes us all better attorneys. It makes us better able to tackle problems, and it gives you more tools, whether you be a prosecutor, a defense lawyer, or whether you're working in civil litigation, more tools to create and craft arguments that can then help to benefit your client or whichever side that you're arguing for. I think one other place that the critical perspective helps prepare attorneys for practice is also for attorneys whose race, ethnicity, gender, age, national origin, or other identity characteristics might be profiled in the courtroom, so to speak. For those of us who are going to be misjudged, underestimated, and that sort of thing, having a critical perspective in your education will also help you to see when these things are happening and help you to be able to deal with them a little bit more effectively. Recognizing the ways that jurors and judges can be inappropriately influenced by appropriate uses of the rules, right, really makes a difference as well. And so, so I try to just give people more tools. That's what I think of in terms of how this helps in practice.
That idea of a toolbox makes me think of the really wonderful work by Chris Henning at Georgetown, who's helped develop the National Juvenile Defender Toolbox that explicitly gives attorneys tools for identifying the way race or bias is showing up in their representation, in the prosecution, and collects motions, supporting case law, supporting social science studies to help people tackle the issues that probably many attorneys are feeling like this isn't right, this isn't fair, but really providing the supportive material to make those arguments. And I think of that as one of the benefits of infusing a critical approach in the doctrinal classes in law schools. Then when you get to practice, you know that you have a chance to name and make concrete the thing that you're feeling is wrong, and gives you access to some of the law review articles and studies that might help persuade a judge who doesn't organically have that same feeling of wrongness. And so I think naming it and supporting your arguments is one of the ways that the things that we're learning in law school can shift into pleadings. And I feel that we've certainly seen that in amicus briefs. There are definitely amicus briefs now, like the ones that Professor Roberts was talking about in the 609 context, that explicitly say, when you have a person of color on the stand and they're impeached with a conviction, here's what we know the jury is doing with that information. These are the implicit biases that are being triggered. I feel I was looking so much for pleadings, non-amicus pleadings, to share with my students in that advanced evidence class. And when I did a survey at the end and asked, what would you like more of? The thing that students wanted to see the most was pleadings that explicitly incorporated arguments about racism and bias. And that was, of course, the hardest thing for me to find. So I told them, quickly go out there, litigate it, send me the briefs, and then next semester, so it's coming soon, I'm sure. But
one of the things I'm hoping to do next year in partnership with my RA, Jenna, who's here, thank you, Jenna, who's already started doing some research on this, is when I teach Daubert, I sometimes get a little bit bored of Daubert, and I feel like one of the things I'm trying to do is find some cases that bring these rules to life for the students a little bit more. And I think one of the things I hope to do next year is try to bring in examples of courts that have approved testimony about excited delirium, which is an increasingly maligned diagnosis. Any of you who are familiar with the Elijah McClain killing in Colorado from 2019 know that the 2 paramedics and a police officer in that case were recently convicted in connection with that killing. And it's a case where when the paramedics arrived, they were told by the police officers that he was suffering from a condition that paramedics and police use this terminology a lot, the diagnosis of excited delirium that's not recognized in medical texts. The responding paramedics then gave McClain an overdose of ketamine, which was part of what led to his death. That case and too many others with similar facts have prompted all sorts of advocacy around the country against this diagnosis. But I've been curious to try to dig in and see how have courts trying to apply the Daubert methodology analyzed that diagnosis. And lots of courts allowed expert testimony about that diagnosis. And I feel like that's going to be a timely issue that students may already have some familiarity with. It's going to give us a chance both to sort of work through what Daubert says it's supposed to be doing, and then maybe question whether Daubert's really a good enough standard. So I think exercises like that, for those of you who are interested, I think Alejandra Caraballo at Harvard has really interesting work analyzing the sort of rise of the anti-transgender medical industry that seems like it's created for Daubert. And so I feel like there are ways to bring these conversations into the evidence classroom, connect it directly with the rules, and really persuade students that nobody wants to just go out and apply something that you think of as the black letter law in this space. You want to go out and change the law, right? And so understanding all of these motivations and implications of these rules is really essential to that project.
Thank you. I'd like to now turn to our audience questions. Caroline has a mic on the side. If anyone would like to raise their hand to ask. Thank you. Professor Dennis.
So we've talked a little bit about this yesterday evening and earlier today. I'd love to hear everyone's thoughts about textbooks and course materials. And I know the answers for some of you, and maybe I don't know the complete answers, and I don't know the answers for all of you. So I'd love to hear thoughts on course materials and textbooks and standard textbooks we all might use, or many of us might use, versus others.
Want me to start? Okay, well, I use my own textbook. I am now a co-author on the book that my late professor created. So Mendez, California, or evidence under the California Code and the federal rules, and then I also have that E&E California evidence. So because I'm teaching California evidence, I may not have as good an answer to your question. But the other materials that I like to include, and it ties into like getting the students excited about a new case, is I have them do an expert witness exercise. So we find a case where there are lots of experts on both sides, that transcripts are available publicly, and usually the case hasn't been decided yet. And so then I'll have them in teams actually do a direct cross-examination of an expert. They have to lay the foundation, get the expert admitted, accepted as an expert, and then they cross-examine each other's experts. And so I try to do those with like high-profile cases if I can find them. And so those are some extra materials that I tend to use. And then every day we have evidence in the news. Somebody's got to bring in something about what happened in the news today about evidence.
I use the Merritt and Simmons textbook, which I find very straightforward and has incorporated some of the comments from evidence professors about what's missing about racial realities. But I also use H2O Open Casebook, which is an open source textbook that anyone can access online. It's completely free. And so I use that as my online textbook, so I can post links to law review articles or to cases or to videos or John Oliver clips or things like that. And it's free. I don't know if I mentioned the free part, but it's free.
I use the Fisher textbook, which I've used since I started, but end up supplementing it with a lot of other things that let me expand on some of these other topics. But there are imperfections with it, but some of them are ones that I can actually start conversations with the students, because why isn't this case explicitly mentioning the race of the defendants and the race of the complainant? How does that change the way you think about it? That may be an argument for me to not use the casebook anymore, but it at least sparks some conversation, so I try to use some of that when I see it.
I use Fisher's casebook as well. And his newest version, the fourth edition, actually incorporates some critical perspectives. So Jasmine's piece is in there, Anna's piece is in there, and Anna's piece references my piece, and there's some others, I think. So the book has changed over time. I think he has an amazing grasp on evidence. I like the way he teaches it, the way he presents it in his book, and what I do. Like, I think I mentioned it before. In my big evidence class, I don't overtly mention race unless it's in the book. So, and now it is, and so there are times when I will. I do it in more subtle ways. I do think we have to be mindful of institutions where we are, and there are times where I've had really hostile students, and I actually don't think it's good, even for the students of color, to be put in an uncomfortable situation where they're subjected to hostility because of something I brought up, or they see me subjected to hostility. But there are other ways to deal with the issue. So again, I think I mentioned I'd use film, and I've used the film 12 Angry Men since I started teaching evidence. I've used it at different points in the course, and so lately I've found that the best way is at the very end. It's an amazing film, and I use the original version. So there are no, for example, there's no Black people in it, but the issue is about race, though. but it's ambiguous. And it's a very interesting way to address the issue of being an outsider, because the race of the defendant remains ambiguous. And so you could fill in the blanks. It could be any particular outsider group at any particular time. And the last time I taught it, I had a student, because I've set the stage. I had a student who asked, how would this be different if these hadn't been, if it hadn't been 12, mostly white men, if that wasn't what we're looking at, and there are no black people on this particular jury, which we're usually dealing with the black-white dichotomy. Certainly, there are other racial implications. This is why I use that, or races that are implicated, in our country, in injustice and so forth. And so that's why I use that, because it's ambiguous. So we don't have the black-white dichotomy, but we can fill it in, and we can fill it in with a number of different groups. And so it sparks a discussion, and then it goes beyond race. We talk about gender as well. But again, I'm setting the stage for it, not overtly bringing it up. I've used other film as well. I use current events. I use the George Floyd case without overtly mentioning race. I just used a film. I used a clip. It was an expert opinion, or expert testimony. The expert who gave an amazing testimony describing exactly what was happening to George Floyd as he was dying, with this man with his boot on his neck. And we talked about it in the context of 702. I never had to mention race. It's all over the place. And again, it set the stage. It allowed the students who wanted to talk about race to bring it up, and I'm happy to oblige. That's the way I handle it, because I do think it depends on your environment. And there's some classes that I have they're going to be more receptive. Some of the smaller evidence, sometimes I have smaller evidence classes, more diverse. I don't have the segment of hostility that I might have in some of the bigger ones. So it just depends on the situation. But I use the Fisher book, and I supplement it with film, and I'm able to accomplish subtly what I think some people may be able to accomplish in environments that may not have that segment of hostility.
Thank you.
And I use Fisher. I've used Fisher, I've used Meriden Simmons, and I've used Jeff Bellin's book as well, and I supplement all of those materials. And just to make a plug for an upcoming book, we hope, I know that Professor Capers is in the audience, and Professor Simon Kerr is in the audience, and the three of us have taken on the task of beginning to co-edit a book on critical evidence that is much like the Critical Civ Pro book that's out there. And our hope is that this will be a combination of the work of many of the people who are here, and we hope that you will submit, but also it's a resource that we can look to more broadly, because this work is just tremendous and incredible and happening. And as Montre said, you look 10, 15 years ago, this wasn't happening. And now we've got this critical mass of scholars who are thinking about this. And so we'd like to have this be out there as a resource and build on the work that you all do.
Thank you so much for that. I think I saw a hand over here. Josh, thank you.
We're always taught as AV technicians, you never tap the microphone because it's bad for it. You always snap. So you've learned something AV related for the day. Thank you all for coming. I really appreciate it and sharing your experience. My question is actually kind of two parts interrelated. And it comes from the perspective of somebody who plans on being a litigator. And my question to you all is, as professors who are teaching litigators yourself, one, I'm trying to imagine that there's this overarching ethical duty that we have as lawyers to advocate for our clients. But what we're discussing is a larger, perhaps moral duty to behave in an equitable manner and use those rules equitably. So my two-part question is, one, this is a little bit outside the scope of evidence, but what do you think about a change to the rules of professional conduct that would require the equitable practice of law in general, not just evidence law? And then two, my question is, even without such a requirement, how should a future litigator go about balancing practicing the law equitably with also advocating, the term zealously for your client comes up a lot. So I'd be curious for all your thoughts. Thank you.
I mean, I don't think you balance it. You represent your client. And if that's not compatible with your ethical approach, then you get a different job. I'm thinking so much, I'm looking at Professor Sinha because I play a video of an interview with Professor Sinha describing how so I'm just going to quote you while you're right here. Is it awkward? Okay.
That's what you said.
But guided by her focus on client-centered lawyering and making it a conversation that she has with her clients. So this is so silly because these are your exact words, but say you have a client in a criminal defense clinic who was prosecuted and incarcerated for a marijuana charge, and you are thinking, well, maybe we should bring up with the judge that this was part of the war on drugs, it was racially motivated, that's part of the reason you're here. And Professor Sinha taught me that sometimes the client says, yeah, I really want to tackle that issue. That's an injustice that I'm focused on. And sometimes the client says, I just want to get out and I want the most conservative path to out. And so truly client-centered lawyering would push more of that into a conversation with the client, and we would be led by the client, I think, in the litigation context. And you could, someone give her the mic in case I misquoted you. Okay, you don't remember, okay.
And so I can answer the first part of your first question on the should the rules of professional responsibility be changed? But I need to sit up. I'm so not used to sitting and talking. I really am used to standing up and talking. So yeah, I would, but it's kind of tethered. Okay, so the ABA has a model rule 8.4.1 that recently came out. California recently adopted it as its actual rule, and it prohibits, it's basically an actionable bar license offense if you, as a lawyer or in the practice of law or in the conduct of your legal practice and work with clients, unlawfully discriminate or knowingly allow unlawful discrimination to occur. So I talk about that in the context of implicit bias. If you know implicit biases are operating in your firm, in your office, in your hiring practice, and people are being discriminated against on these inappropriate bases, then that could potentially be actionable as an ethical violation. So I think that is one place, so there is some movement there. I don't know how many other states have adopted it, have adopted that rule, but putting it on the lawyer, not just as an individual moral ethical person, but also as an officer of the court who wants to keep their bar license.
Thank you. Do we have another question? Okay. We've already touched on this a little bit with regards to some of the recently very publicized, at least in the past few years, backlash against certain critical perspectives in education. So I'm wondering if you could speak a little bit more on how you continue to advocate for those teachings in your own classrooms, as well as push others to commence teaching them in places where they may not currently be taught.
I'm happy to jump in for a moment, just to say that, and this also connects to the last question and set of answers, that good lawyering is going to necessarily entail doing this work. And so the more that we see this or frame it or encourage discourse that has it be separate or extra, I think we run into, replicating the silos. So I think, the example and some critical aspects more than others, right? So I mentioned flight as proof or probative of guilt, which is pretty central in our evidence doctrine. And I think for a number of reasons, for disability and otherwise, bringing up those arguments and raising the kind of disability point would be a strong argument, right? That's going to advance your client's interest. And so it's not disconnected or antithetical, but it is a core part of it. So I would encourage us all to continue to see this as this is good lawyering. This is what we're required to do.
I guess maybe I would add to that and say one of the things that I think has come out on the prior panels is that being successful in making these arguments is an interdisciplinary effort. And so I guess when I feel pushback, I just try to go get more evidence. And some of the best evidence involves leaving my law silo and, you know, finding criminology scholars or sociologists or other social science, psychology studies, where, find the data that supports the arguments that you're making and use it. And I made notes earlier thinking about, like, even going beyond that sort of interdisciplinary thinking when Anna and Julia were talking about their work. They need a web designer, they need PR folks, right? Like trying to expand the way you think about solving these problems, finding partners in the community, making sure that you're bringing in the voices of people who are directly affected by the way these rules work. It just feels like you sort of broaden the network of people whose work you're relying on in support of these reforms.
Thank you, and go ahead, Professor Dennis.
Right, so one of the things that at least all faculty have in our support, and everybody knows, right, we're looking for ABA accredited law schools, right? And the ABA does mandate that law school curricula include this type of material. They don't use the term critical anything, critical race theory or any crit version, but they do mandate that an approved law school teach this type of information, right, as part of a curriculum for good lawyering and preparation of lawyers. And so I think, as one who's in a state that may or may not face some challenges in this area, right, for law schools, professional schools, that we are servants, right, to our clients. And part of that is good lawyering and being able to understand the arguments, criticize the arguments, make the arguments, present the arguments appropriately, consistent with your representation. And so I think, at least as the legal profession, we always have that background professional obligation within which we are training lawyers and within which lawyers operate. And so we can't avoid it. This is, as we all know, this is part and parcel of law. Right? That's the whole point here, right? Law is not neutral as others might proclaim. And so I think just if you're thinking about slightly outside, ABA accreditation expects some of this to be taught.
Yeah, and I would just say one quick thing in response to your question. In terms of encouraging, when I teach about these theories, I also teach the critiques of the critical theories as well, so that it's not that I'm just giving one side, so it doesn't give the same sort of ammunition to someone who may want to go rise up to the administration and, put me in my place.
Oh, wait, and that made me think of how we're sharing the information are encouraging, just lifting up a series of webinars that were put on by the Law School Anti-Racist Consortium that invited professors on different doctrinal topics to present on how they teach property or torts or evidence with a critical lens. And those are free and available, and I thought that was like a great way, because part of it for many of us, it's intimidating to tackle a topic that you haven't taught before, and I certainly myself worried that I didn't have the theoretical basis to teach my class and that I wasn't qualified. And these videos, or even just seeing someone else's syllabus, helped me see, okay, it's doable. This is a task that I can take on. And so I think having that available for others who are interested but maybe a little intimidated is a helpful resource.
And Dorothy Brown has a book, I think it might be in its 4th edition, that's like a little handbook, and it's called Critical Race Theory, and it's just got one chapter for each doctrinal subject. So it's something you could do in one class period, or your faculty could do in one class period, or you could stretch it out for more.
Thank you. Do we have another audience question?
Thank you. Professor Goodman, it sounds like in your classes, you're teaching both the California Code of Evidence as well as the federal rules. And I was lucky enough to have JSK as Professor Simon Kerr, sorry, that's a nickname we have for her, as my evidence professor. And we focused a lot on the federal rules. And as someone who's planning on practicing in the Connecticut courts, which are very much influenced by the federal rules, but obviously have their own tweaks, I was wondering if you could speak to the benefits possibly of teaching the code of the state that you're teaching in, if you have a code in your state that you are teaching in.
Yeah, so teaching at Pepperdine in Malibu, lots of people come from out of state. Many of them stay afterwards, okay? So they say they're not going to practice in California, and then they end up taking the California bar. So that's why I decided I should teach California evidence, because the rule numbers are completely different. Some of the rules are very different, and most of my students are not going to be federal court litigators, right? If they're just starting out, opening their own shop, they're going to be in state court most of the time. So that was my rationale for doing that. And so if the codes are different in the states, then I would say it's really useful if we want to not just help our students to pass the bar exam, but help them to actually practice. Having them be comfortable with the rules that they're going to be later using, I think is really, really helpful. A lot of schools' trial practice classes focus on the federal rules because that's kind of the common thing. But so the students who do take trial practice or trial advocacy are in the habit of objection, 401, objection, 404 or whatever it is. But if you need to say the objections that aren't, that are different numbers, then it's better to get practice doing that. And I make my students stand up and object because, I teach after lunch. So that I think is one thing. And I think the other thing is, the other reason that I do it is because the California bar exam tests both. Okay, so the multiple choice is only the federal, but the essays and the performance tests can be federal or California. So even for those who are just taking it in the spring because it's required and because it's on the bar, I'm still helping them towards that. But I'll just mention one other really important difference besides the rap lyrics exception that we have. We also have an exception for domestic violence. So like the 413, 414 sex crimes, we have a domestic violence exception. So those who are charged with domestic violence, prior instances of domestic violence, whether convictions or not, can be admissible. So I don't know if the arguments against the sex crimes ones are as compelling against the domestic violence ones in terms of recidivism, but there's some important areas like that. Same with the character of the victim. If you want in California to bring in character of the victim in a criminal case, we can use specific instances. We're not limited to reputation and opinion. So that makes huge differences in terms of how you actually practice.
We have time for one more question.
Thank you all for being here. So my question is regarding practicing attorneys. So I know as professors, your dream is that us as law students continue on and use your arguments and develop these ideals that we take into practice. But for attorneys that are practicing today and haven't heard these arguments before, what are some ways that you would recommend they do to learn about these novel arguments and develop them and develop strategies to implement them in their office and their practice, et cetera?
When I was practicing, the way that I hope I contributed to some of this was by taking basically the Crit's handbook and just asking these questions as we talked about the status of a case or the case law itself on which we're trying to argue, and just injecting it into our ordinary conversation about the case. So not necessarily saying, folks, it's time for us to do our critical evidence roundup or our critical theory roundup, but just bringing it in as, look, we're missing this opportunity to advance this point. Here's why context matters in this instance. So I think that's the kind of, everyday way to do it. And then I think that, as many on the panel have said, there are tremendous resources that are becoming available, everything from podcasts to videos to books, law review articles. But I think really in conversations, day to day, there are ways to inject these critical questions.
I would also think, like, a couple steps. One, ask the interns in your office, what are they upset about? Because every time I teach evidence and the students are like, wait, you know that limiting instructions don't work, and yet the whole system is propped up this way? Like, those reactions are good signals that could kind of reawaken questions for those of us who are more familiar or worn down by the rules. And then, this is maybe too obvious to say out loud, but I'll say it, is, you know, sometimes to Google a law review article, which of course is going to be aspirational, and then look at appellate briefs that cite it. And then I sometimes find an amicus or at least a model motion that I could borrow. So that's just one tool I use.
Yeah, and there's another guide, I can't quite remember the name, it's like Guerrilla Guide to Evidence. Yeah, just a short, it's maybe 10 pages or something, but it has links to articles and cases. So that would be a quick way to be able to, you know, access some things. And then the other thing I recommend is, again, you can do a Google search, look at like whatever rule is at issue, say it's Rule 702, you can just search for critiques of FRE 702, and then you can read the titles of the law review articles and be able to find, you know, maybe more than you want. But that would be another way if you have some specific rules that are at issue. Guerrilla Guide will give you some general things.
There's also a database of defense briefs. I don't know what field you practice in, but for those of you who are going to be criminal defenders, raising racial injustice issues, and you can search by topic. I'm like trying to make eye contact with other panelists. Do you remember what the name of it is? It's called Data for Defenders. Thank you.
All right. Well, thank you. Unless any of the other panelists have any further remarks, I think that concludes panel 3. Thank you everyone on panel 3 for your contributions. And with that, that also concludes the Connecticut Public Interest Law Journal Symposium.